If you or someone you know has been charged with a crime, it's probably the scariest day of your life. Hopefully it's the first time it's happened to you, but it's probably something you never thought would happen, something you're really scared about right now, and that's why you're watching this video. And you probably got a court notice in the mail for a preliminary hearing. So you don't want to do that wrong. Today, let's talk about 3 things that people do wrong at preliminary hearings that I see all the time. I'm Josh Camson. I'm a criminal defense attorney with Miller, Turetsky, Rule, McLennan. I practice all over Pennsylvania. Let's dive in. Number 1, people testify for themselves. People think, oh, it's a preliminary hearing, it's at a magistrate, it seems very informal, the judge might not even be wearing a robe, you're kind of at your local court. People don't take it seriously. They think it's me versus the other person, or me versus the police officer. And what they forget is anything they say on the stand can be used against them. That means if they make a statement that the police later find out is untrue, they can use that against the person. It's not a good idea. Horrible idea to testify in your own defense at a preliminary hearing, as well as calling witnesses. The rule at a preliminary hearing in Pennsylvania is that the magistrate judge is required to assume the facts that the Commonwealth presents are true. And if they are, do they meet the law? That's it. Credibility is not an issue. So if you have someone that's going to say the government's witness is a liar, that's not going to get you anywhere, but it is going to show your hand. Not a good idea. So mistake number 1, testifying and presenting evidence at a preliminary hearing. Mistake number 2, not recording the hearing. Now, in some counties, the court will record this for you and it gets transferred to the Court of Common Pleas. You can get a transcript, no big deal. But in a lot of counties, you can't. But you are allowed to electronically record these hearings, and it's so important to do so. Because if there's no recording, there's no proof. Somebody says A, and then later they say B. If you don't have a recording that you can turn into a transcript, it's become effectively useless. You can't impeach them with that testimony. You can't use it to show the Commonwealth that their case is weak. It's pointless. It's as if the entire proceeding never happened. Always, always, always record it. Or even better, bring a court stenographer. Court stenographers aren't cheap. You got to pay them to go there, pay them to type up the transcript. So I usually only do that in much bigger cases, your homicides, your rapes, your serious sex crimes, but it is an option. But for lower level offenses, your misdemeanors and low level felonies, recording it on your phone, totally fine and allowed under the rules. The third mistake people make at preliminary hearings, not bringing a lawyer. Come on, I'm a lawyer. You knew I was going to say that, right? If you have a lawyer, hopefully they're not making these mistakes. Hopefully they'll advise you not to take the stand, not to present witnesses that you don't want to show your hand to the Commonwealth about. And of course, the lawyer will know to record it or how to get a court reporter there so that the whole thing is recorded. Because the preliminary hearing isn't just a throwaway thing. Some people just waive it. Oh, I'll get there, I'll waive it. And there are circumstances where you can waive it, but a lot of times you can gather a lot of information at the preliminary hearing. It's an early glimpse at the Commonwealth's evidence. It lets you start formulating, especially if you're the lawyer, start formulating what's my strategy here going to be? What are the suppression issues? What are the evidentiary and the legal issues? How are we really going to attack this thing? And of course, it's also an opportunity to argue bail. Now, I have a whole other video on preliminary hearings at different counties. So far, I got Montgomery County out. We got Lancaster County coming, Chester County, Delaware County, Berks County, etc. But at the preliminary hearing, you are able to argue for bail to get that bail reduced if it hasn't been set by a common pleas judge. So that's very important as well. I hope this has been enjoyable. I hope you've learned a little bit about preliminary hearings in Pennsylvania and ways to not screw them up. If you have found it useful or found any value in it, please subscribe to the channel, share the video so other people can find value too. Thanks a lot.